In property law, a person may acquire ownership of another's land by adverse possession by actually possessing the property in a way that's continuous, hostile, open, and notorious for the statutory period, and exclusive. Exclusive possession generally requires a party to assert its right to use and control the land as its own. But what if two parties share in the use of the land, and there is a mistaken belief about who owns the land? Can that possession be exclusive? The Texas Supreme Court considered this question in the case of Tran versus Macha. In 1970, Lillian Halliburton purchased a lot in a subdivision in Texas. At the time, Halliburton's sister-in-law's family, the Budds, owned an adjacent lot. The lots in the subdivision were 55 feet wide. However, houses were built on the lots under the mistaken belief that the lots were only 50 feet wide. Consequently, some of the houses on the lots, including the Halliburton's home, were built on the lot's easternmost boundary. Moreover, lots had a shared driveway with a separate garage for each owner. The driveways were built on a 20-foot strip of land directly in between lots. But because Halliburton's driveway and garage were constructed east of her home, they were built on the Budds' lot. Halliburton and the Budds used the driveway for numerous years to access their garages. Halliburton presumed that the driveway and the garage were on her property. In 1995, the Budds sold their land to Min-Tu Tran and Norman Roser. 6 years later, Halliburton sold her lot to William and Nita Macha, who already owned the lot to the west. Following a land survey, the Machas discovered that the shared strip of land was on Tran and Roser's lot. The Machas later received a quitclaim deed from Halliburton conveying any interest she may have acquired by adverse possession. Tran and Roser then built a fence around the strip. Subsequently, the Machas sued Tran and Roser in state district court, claiming they obtained title to the strip by adverse possession. Following trial, a jury found for the Machas. Tran and Roser appealed, and the Court of Appeals affirmed. The Texas Supreme Court then granted review.